Oil giant Shell has been ordered to halt its seismic survey along the country's wild coast. This after the High Court in Makhanda interdicted it from proceeding with its activities. It's a major victory for environmentalists and fishing communities in the region. Those opposed to Shell argued the surveying that started early this month was devastating to the marine environment and hurt the income and cultural practices of surrounding communities. Attorney at the Legal Resources Centre, Wilmien Wicomb, joins us now. Wilmien, thanks very much indeed for your time in talking to us. This was a second attempt to secure an interdict against that seismic activity. The first one failed. What did the court see differently this time round?
So two things, I think, were the major differences in the two cases. So the first one was that the applicants in the second interdict are small-scale customary fishing communities along the wild coast. And there's no denying that they were absolutely never informed or consulted by Shell. Not at all. So it was not even an argument about the quality of consultation, but it simply didn't happen. So that was a major difference. In the first application, the applicants were recreational commercial fishers who also complained about the quality of the consultation, but at least they knew that this was happening. So that, I think, was the first major difference. It is really telling because these fishing communities that were never consulted, they have constitutionally protected customary fishing rights along that coastline. So it's extraordinary that they were ignored in the consultation process. The second significant difference, I think, was that these applicants were able to put evidence before the court. They had 10 different experts who filed reports saying that in all likelihood significant harm will follow to marine life and otherwise from these surveys. And that gave the court, I think, the confidence that they knew that indeed this is not only speculation but harm will follow.
But here's the caveat, if you like. I mean, it's an interim order, isn't it? And it's interesting that during arguments Shell said that it might have to walk away from this entire operation. Do the groups have enough financial capacity to continue with this fight if indeed it does go on?
I do think so. So the first thing I should mention, as you probably know, is that we were awarded a cost order by the court today. So Shell and the minister must pay the costs. Then, the communities are supported by the Legal Resources Centre, that where I work, and we do the work pro bono, and other attorneys who are on the case. A public fundraising exercise has been undertaken where people can donate money, and that is ongoing. I think the public interest in this case is huge, and so. We certainly at this stage don't I have no real concerns about the financial implications. Look, so this is, of course, this is an interim interdict. The next step will be to argue the final interdict, and that we're not far away from that. I certainly see us reaching that point fairly easily at this point.
You've just touched on something very important. I mean, the court process is a multi-layered one, isn't it? I mean, what really essentially happens next year?
So, I mean, a number of things will likely happen. One is that you might know that in the first interdict, those applicants appealed. This interim interdict today will most likely be appealed by Shell. It won't suspend the order. The order will stay in place, but they'll likely do so. And then we will argue about a final interdict. It raises a different legal question as to whether Shell must first do an environmental impact authorization before they can do this exploration at all. Once that is granted, which we believe it will, then that will likely also be appealed. And then there are also other layers to this, which deals with the authorizations granted by the minister. Which, on the evidence before the papers, it looks like the minister really should not have granted these exploration rights, given that the consultation was a sham. And so, I foresee that those kinds of reviews will also reach the courts. It's a long road ahead, but we're certainly very confident. And today was an excellent start.
Yeah, indeed it was. But I want to move on to another fishing community, Wilmien. On the other side of the country, the Olifants River mouth, which enters the Atlantic Ocean. I mean, there you have government granting Australian mining company Mineral Sands Resources essentially the right to prospect for heavy minerals. Now, as I understand it, a very similar situation there in terms of social impact. Tell us more and your involvement there.
Yeah, so it's an extraordinarily interesting case and really quite devastating. So the bigger background that I think is really important is that Olifants River, there's also a fishing community there, a traditional fishing community, so similar to the Wild Coast. But they're part of a bigger Ebenezer community, which is actually a restitution community. They won the biggest land claim in the Western Cape after 20 years of struggle. That land claim was settled only a year ago. And, you know, the ink was not dry on that settlement agreement, and the ministers started handing out prospecting rights on the land that was just newly restored, and indeed impacting the estuary and the ocean. So there's even a different and very significant aspect to that Olifants case. It just seems unthinkable that, you know, you would allow a community to finally regain their land and then immediately allow for mining on that land without the proper consultation once again. So in the case of Olifants River, we know, for example, you know, that there were community meetings, but that those ended kind of in chaos because the community, the fishers and so on, was so opposed to the granting of these rights. But, you know, that was ignored, and they simply went ahead and granted these prospecting rights.
It is puzzling,
I think the real issue...
Go ahead.
Sorry, I was going to say the real issue is also that you have various different mining companies who target different areas, but all along the same kind of coastline, right? For a huge stretch of land, and so these applications are all considered separately. So there's no one who's looking at the cumulative impact of all these different prospecting rights that may well end up being mining rights. And I mean, a proper study should be done, but from the little that we know, it's clear that it's going to be devastating.
Just before I let you go, I mean, does it surprise you or does it puzzle you that the Environment Department, for example, would have had this stance on that particular Olifant River situation?
It is puzzling that they had this stance on the estuary and Olifants River, in particular because fishing communities fall under the same department. So, you know, the same department knows exactly how long these communities have struggled for the recognition that they finally were granted. And just as that happened, it's threatened to be taken away without considering that. So, yeah, it is deeply puzzling.